Yes, Mr. Hall.
I'm grateful. My Lord Justice Henderson asked before lunch about what elements of the decision in life formed the ratio. My understanding of the principle, without checking their case law, is that the ratio includes the essential reasoning of the judgment. And it would appear to my learned friend and I, Ms. Inglis, that on this point, the essential reasoning is in paragraph 61, 73 and 78. 61 on page 406, where Counsel for Life advanced two criticisms of reasoning based on the King's criticism and FBT cases. First, he submitted that the UT had been wrong to rely on FBT, and secondly, he submitted that the UT had failed to ask itself the right question, which is whether regulation made any significant difference to the consumer. I accept the second submission, and therefore it is unnecessary to consider the correctness of the first submission. So it seems that the passage after secondly does appear to form part of the reasoning of the court, particularly when one then turns to 73 and 78. At 73, Learned Lord Justice Arnold said, I consider that it was open to the Upper Tribunal to conclude that welfare services provided by state-regulated private welfare bodies are significantly different to those provided by non-state regulated private welfare bodies in the eyes of consumers. Moreover, I agree with the Tribunal's assessment. And at 78, below letter B, I consider that viewed through the eyes of the consumer, just as there is a significant difference between welfare services provided by private welfare bodies, which are not state regulated, and those which are, so too there is a significant difference between welfare services provided by private welfare bodies, which are not state regulated, and those which are provided by charities. So those appear to be the relevant elements of the reasoning of the court. One will see also, though the headnote is not part of the court's judgment, that the headnote writer on page 393 appears to have considered that the reference to the consumer perspective, one will see under little 2 on page 393, was part of the essential reasoning of the case when compiling the headnote, at least in their view. From that, I think the revenue would struggle to argue that that feature of life wasn't part of the reasoning and therefore part of the ratio. However, I maintain the point that I made without authority before the lunchtime adjournment, that this case is special because it relates to points of European law, and with her customary diligence and enthusiasm, my own friend Miss Inglis has both found the case that I was vaguely thinking about and also gone and got copies of it. So it may be in front of you already, my lords. It's a case called Commissioner of Angada Shikona, which is an Irish case. Case C37817 is a judgment of the Grand Chamber of the Court of Justice, so with 12 judges sitting. And I can briefly summarise it, but then get to the point of what it decides, which is, it was a case where two gentlemen were excluded from the procedure for recruitment of new police officers to Angada Shikona, which is the Irish National Police Force, because they were above the maximum age for recruitment. That's at paragraph 11. They complained to the Irish equivalent of the Employment Tribunal, which is the Equality Tribunal. The difficulty that they had was, if one looks at paragraph 6, Ireland has a written constitution, and the Constitution of Ireland specifies in Article 34.2 that the courts of Ireland comprise courts of first instance, a court of appeal, and a court of final appeal, which is the Supreme Court of Ireland. So that's paragraph 6. And then at 7, Article 37.1 of the Constitution of Ireland states that nothing in this Constitution shall operate to invalidate the exercise of limited functions and powers of a judicial nature in matters other than criminal matters by any person or body authorised by law to exercise such functions and powers. So the courts established by the Constitution were only the High Court of Ireland, the Court of Appeal of Ireland, and the Supreme Court of Ireland, not the Equality Tribunal. And therefore only the Equality Tribunal, only the High Court of Ireland could declare that Irish law was incompatible with community law. The Equality Tribunal was not constitutionally able, if it found that there was an incompatibility between Irish law and community law, to declare that the Irish law was incompatible. And that was the problem that Mr. Boyle and the other gentleman had. The Irish Supreme Court said, well, that's not a problem, is it? Because Mr. Boyle and his colleague could always petition the High Court of Ireland, and that would remedy the situation. And you'll see the question at paragraph 24, where the Supreme Court of Ireland asks at little b, where national law would require that a particular body, which here was the Equality Tribunal, not have jurisdiction in a limited category of case where an effective remedy would require the disapplication of national legislation on the basis of national or European law, but appropriate national courts would have jurisdiction to make any appropriate order disapplying national legislation. So what they're saying is that the Equality Tribunal can't do anything about this, but the High Court could. And the question is, must the statutory body concerned, that's the Equality Tribunal, nonetheless be taken to have a jurisdiction to entertain a complaint that national law was in breach of relevant European Union law? And then at 31, you'll see the referring court asks, in essence, whether EU law, in particular the principle of primacy of EU law, must be interpreted as precluding national legislation under which a national body established by law in order to ensure enforcement of EU law in a particular area lacks jurisdiction to decide to disapply a rule of national law that is contrary to EU law. So do you have to wait? Is it permissible to say, don't worry about the fact that the Equality Tribunal can't do anything about, can't disapply national law in order to enforce the relevant directives? The gentleman concerned could always go, or I think they were gentlemen, could always go to the Irish High Court. And the Court of Justice resoundingly says no to that at 35 and 36. The court says, the primacy, this is the Grand Chamber, the primacy of EU law means that the national courts called upon in the exercise of their jurisdiction to apply provisions of EU law must be under a duty to give full effect to those provisions, if necessary, refusing of their own motion to apply any conflicting provision of national law, and without requesting or awaiting the prior setting aside of that provision of national law by a legislative or other constitutional means. So what we take from that is that this court, although it would be bound by Young and Bristol Aeroplane in any case concerning, or any point of law concerning UK law, where the issue is whether, if this court considers that we're correct on point 1, but the only thing preventing the court following its decision that the revenue are correct on point 1 is the life case, then the primacy of EU law requires this court to give full effect to EU law, refusing of its own motion to apply any conflicting provision of national law without awaiting the prior setting aside by legislative or other constitutional means. And we take from the words other constitutional means must be waiting for another court to fulfil the function of ensuring the primacy of EU law. So in this case, waiting for the Supreme Court to reach a conclusion. And then at 36, accordingly, any provision of a national legal system and any legislative, administrative or judicial practice, and we underline that, judicial practice, because that's what Young and Bristol Aeroplane is, which might impair the effectiveness of EU law by withholding from the national court having jurisdiction to apply such law, the power to do everything necessary at the moment of its application to disregard national legislative provisions which might prevent directly applicable EU law from having full force and effect, are incompatible with the requirements which are the very essence of EU law. In this case was about national legislation as compared to EU legislation, but the primacy of EU law must require the court, and in fact does require the courts to follow the decisions, while member states, or in periods in which the UK was a member state, to follow the decisions of the CJEU. And that general principle is set out at 39. The principle of primacy of EU law requires not only the courts but all the bodies of the member state to give full effect to EU rules, and that includes the decisions of the Court of Justice. And then that is reinforced again at 49 to 51. This court included the UK judge at the time, my colleague who has since returned to Chambers, Sir Christopher Vida, was one of the judges. And we'll see from the signatures at the end. But 49 to 51, rules of national law, even constitutional provisions, which this was in the Constitution of Ireland, cannot be allowed to undermine the unity and effectiveness of EU law, at 49. And at 50, it follows from the principle of primacy of EU law that bodies called upon within the exercise of their respective powers to apply EU law are obliged to adopt all the measures necessary to ensure that EU law is fully effective, disapplying, if need be, any national provisions or national case law that are contrary to EU law, and that includes national case law, Bristol and Young and Bristol. This means that those bodies, in order to ensure that EU law is fully effective, must neither request nor await the prior setting aside of such a provision or such case law, which again includes Young and Bristol, by legislative or other constitutional means. In this case, consequently, the fact highlighted by the referring court, which is the Supreme Court of Ireland, that in the present instance, national law permits individuals to bring an action before the High Court and allows the High Court, if it upholds the action to disapply the national provision at issue, is not capable of calling the above conclusion into question. So we say that must apply equally, that that one cannot say that the relevant national case law, which is here Young and Bristol, and or the rule in Young and Bristol requiring that life services be respected by a second court of appeal unless the limited circumstances in Young and Bristol apply. One can't say that if this court considers that life was decided incorrectly, that the revenue must wait until the Supreme Court has had a chance to consider the matter, because that's precisely the point in that case, that the Court of Justice said that Messrs Boyle, the two applicants who hadn't been able to join the Irish police force, didn't have to wait to bring an action before the High Court. They were entitled, if the Equality Tribunal decided that community law required them to be, or that it was incompatible with community law for them to be excluded from the Irish police force on the grounds given, they couldn't be required to bring an action before the High Court to vindicate that right. Any court which had jurisdiction to deal with their dispute was obliged to adopt all the measures necessary to ensure that EU law was fully effective. And therefore, we say that in this case, if we've persuaded the court that the assessment of fiscal neutrality is not required to be assessed from the consumer perspective as far as the supply condition is concerned, so life is unfortunately incorrect, that one doesn't have to, and if one cannot bring oneself into the exceptions in Bristol, Young and Bristol, one doesn't have to wait for a decision of the Supreme Court. The Court of Appeal is not just entitled but required to adopt all the measures necessary to ensure that EU law is fully effective, including disapplying any national case law in the way. Obviously, that only applies in this case because at the time, the relevant times of this appeal related to periods in which we were members of the European Union.
This is a constitutional rule, effectively, saying that you must apply European law. We no longer have to do that.
That was what the Brexit debate was about, for good or ill.
And it was decided.
That was decided.
So there's no longer a principle of primacy in this sense.
No. I suppose that was the issue of principle, that those who wished the UK to leave were making, that we were required to do everything to ensure the effectiveness of EU law, and that's what one of the issues of principle that the debate was about. And so obviously we no longer have to follow that constitutional rule, but in the periods that we're dealing with, we are applying European law because the dispute related to the periods between 2012 and 2016. So those are our submissions, at least in the time that we've had available to consider the point on that point. Given the indication by my learned, my Lord Justice Lewison as to the pressing time, I wonder if I can turn to, with the leave of the court, to ground 2. We make 2 points on ground 2. One point about the UK and one about the EU. We've got effectively what one might call an inconsistency argument or a query as to exactly what my learned friend is saying on the UK case law, and I can briefly explain that. We say that my learned friends fundamentally contradict themselves because they appear to have accepted the decision in FBT in the Court of Appeal, where the Court of Appeal held at 54. I think you might have seen this already, that it was open to the UK to decide which non-public bodies were to qualify for exemption and then specify them in a list. But then, on the other hand, my learned friends say that it's not permissible to exclude entities from exemption on the basis of criteria that don't apply to everyone. But we say, well, it's difficult to reconcile what the appellants are saying, because it's intrinsic to the list approach approved by the FBT, by the Court of Appeal in FBT, that if you have a list, that there are different criteria to different bodies listed. Otherwise, there wouldn't be multiple entries on the list. By having a list with multiple entries on it, there must be different criteria. I mean, they seem to, at different times, say 2 slightly different things. At one time, for example, in their skeleton at 49, they say that the FTT and the Upper Tribunal were wrong to distinguish the appellants on conditions that didn't apply to all exempt providers of higher education. So they're saying that it would appear that there should have been conditions that applied to, the same conditions should have applied to everybody covered by, sorry, I'll rephrase that. So I think it's their skeleton at, so I'm looking at 49 and 51 of their skeleton, which is at, Yeah, so at 51 they say it is well established, citing Zimmerman, that the principle of fiscal neutrality precludes the denial of the exemption on the basis of the absence of a feature not shared by entities to whom the exemption doesn't apply. So they seem to be putting forward a case that there can only be one set of criteria for everybody covered by the exemption as a whole. But then at 49, just before that, they say the appellants respectfully submit that the Upper Tribunal was wrong to distinguish the appellants on these bases, since these are not conditions that apply equally to all exempt providers of higher education. So there's a question as to, already in their skeleton, as to whether you're saying that there has to be a single set of criteria for the whole of the exemption for education, or one is entitled to have separate criteria for different aspects of education, i.e. one set of criteria for the exemption of providers of higher education. So that's the first point. So they appear to now be accepting that you can have different conditions to different subcategories of education, i.e. you can have different conditions for example, school education, and then a further set of conditions for higher education, i.e. that you're only required to have similar conditions for a subcategory of education. We say that the Court of Appeal has already rejected the submission that all beneficiaries of the education exemption have to be assessed by reference to the same criteria, and we, as I say, refer to the FBT Court of Appeal case, where the Court of Appeal there approved as compatible with EU law Parliament's approach of deciding which non-public bodies were to qualify, and then including a list of them in the relevant legislation. That's
But presumably, if we think it's wrong, you say that we are required to apply EU law.
I think we have to, yes. It's what's source for the goose is source for the gander. You're right. But we say there is a tension in their disavowal of they say that they're not criticising the list approach in FBT, but there seems to be an inherent tension in what exactly they're saying as to whether you have to have the same criteria for the whole exemption or part of it. If part of it, how do you define what part is? And also a tension in their acceptance of the list approach in FBT, whereas a list approach must, by definition, have different, if you've got different categories in a list, there must be different conditions applied to them, otherwise there's no point in having a list. But anyway, what's important is to go on to the EU case law, which the learned friends rely on. They particularly appear to rely on Zimmerman, LUP and IGMBH. The point here is that in Zimmerman, and again I'm grateful to the learned friend Ms. Inglis, and in also in I think it was in at least one of the other cases. In fact, it was in LUP. Both of them were German cases, which required the issues concerned the way in which the German VAT Act had translated into German law the requirements in point G in Zimmerman, and in LUP was point B. We have got, thanks to Ms. Inglis, the English translation. We've got both the German and the English translation of the relevant passages from the German VAT Act, and they're at tabs 49 and 50 in the bundle. There's a minor correction to make. There's the wrong sidelining on the German version if the court wanted to know which bit of the German. So this is the official Bundesgesetzblatt, which starts at 972. The sidelining is actually on the wrong, of the German is actually on the wrong page. So the sidelining that the court has is on the right-hand side of 990, which is a sub-clause 16, but that is actually the wrong sub-clause 16. The right sub-clause 16 is on page 980. So in fact, the sidelining should be starting at the bottom of 980. Once there's a little 16 there, it should run down the right-hand column where it says Die mit dem Betrieb der Krankenhäuser, Diagnose, Kliniken und anderen Einrichtungen at the bottom 980, and then over the page on the left-hand side of 981 down to the words ganz oder zum überwiegenden Teil getragen worden sind, halfway down the page. And the English translation starts behind tab 50 at 1007, and the relevant 16 there, this is Article 416 of the German VAT Act, paragraph 416. This sets out the exemption for the implementation in Germany of the exemption for hospitals, diagnostic clinics and other establishments providing medical care, diagnoses or clinical results. And it sets out A to E, the different possible categories. So A is bodies governed by public law, and then B, C, D and E are all other forms of recognition. So you've got, in the case of hospitals, they have to supply one set of conditions which are laid down in paragraph 67 and 67.2.
Sorry, which page are we on there?
We're on 1012.
1012, thank you.
So the way that Germany has implemented the exemption for hospitals and diagnostic clinics was to specify for different types of entity, one will see A, bodies governed by public law, and then for each different type of entity, what the conditions are. You'll see B is hospitals, the conditions are laid down in 67.1 and 67.2 of the tax code. 16C, in the case of diagnostic clinics, providing medical care, diagnoses or tests, provided under medical supervision, and in the previous calendar year, at least 40% of the services were provided to the person specified in paragraph 15B. There are insured persons, the recipients of social welfare benefits, etc., etc. That's back on the previous page, 1011. D, in the case of old persons' homes, residential accommodation for the elderly in nursing homes, at least 2/3 of the services in the previous calendar year were supplied to the persons specified in paragraph 68.1 of the Bundessozialhilfsgesetz. And then E, in the case of establishments for the temporary admission of those in need of care in establishments, providing outpatient care, the costs of the care in the previous calendar year were borne in at least 2/3 of cases, wholly or mainly by the statutory social security or social welfare authorities. So what Germany has done is to set out a list with the bodies governed by public law, and then the other bodies who are recognised. Each of them have specific conditions that apply to them, which is precisely what my learned friends for the appellants say that Germany or member states aren't entitled to do. The question is, what did the Court of Justice decide in Zimmerman, LUP and IGIM BH As far as Zimmerman is concerned, which is at 34, tab 34, page 675, and that was the case about G. It'll take me a moment just to explain that case, but the I'm just working out which bundle we're in. I think we're in bundle 2. Yes. So it's a page, it starts at 675, Zimmerman. But the complaint in that case was because there were 11 organisations on what was called the approved list, and then there were the services supplied by Ms. Zimmerman. One will see that from 17 and 18 on page 695. And those services supplied by the 11 bodies were similar, if not identical, to those supplied by Ms. Zimmerman. You'll recall at 9 that Ms. Zimmerman was a registered nurse and worked at a welfare centre as a staff nurse, but she also cared for patients. And she was recognised, and we'll see from the last sentence of 12, as recognised for the purposes of social security law as a charitable organisation. But the issue in her case was whether she'd satisfied the 2/3 of cases point, which is little e in the list we just saw a moment ago. We'll see that in paragraph 11 of the court's judgment, and also the assessment of the 2/3 had to be assessed in relation to the preceding calendar year. So the point was that at 17 that 11 bodies were exempt. She wasn't, as far as the German tax authorities were concerned, although she was recognised as a charitable organisation, she didn't comply with the 2/3 rule, and she didn't, and that especially on the basis of assessment from, well, by reference to her transactions in the previous year. The problem wasn't about multiple gateways to the same exemption in that case. The question was, within the exemption, the differences between Mrs. Zimmerman and the 11 organisations. So if one turns then to paragraph 45, it said that the German government maintains that the condition at issue in the main proceedings, including in particular the 2/3 threshold, is supposed to guarantee that the service provider concerned is truly a charitable organisation and serves to ensure that it is placed on an equal footing with public law bodies. However, according to that government, since paragraph 1418 of the German VAT Code, in contrast with 416, which is the provision which sets out the 60% threshold, the 2/3 threshold, covers only non-profit making legal persons whose charitable nature has been formally established. The German legislation is not treating identical taxable persons differently. Rather, it merely lays down for recognition as charitable organisations different conditions for different taxable persons whose material and legal circumstances are different. What the court said was at 53 to 55, it is not in relation to bodies governed by public law that the principle of fiscal neutrality requires equal treatment in terms of recognition as charitable, but in relation to all other organisations, each as compared with the others. As the German government confirmed at the hearing, the organisations covered by paragraph 418, which are exhaustively listed, are governed not by public law but by private law. It is true that, as the German government argues in substance, the principle of fiscal neutrality cannot as such preclude refusal of the exemption under 13 and point G to organisations which, like the applicant in the main proceedings, systematically aim to make a profit in accordance with the option available under what's now 133A. And then over the page at 56 to 58, there was nothing to show that Germany had availed itself of that option. And then at 57, the court then says that point G applies the concept of organisations recognised as charitable under point G. That concept is in principle sufficiently broad to encompass natural persons and private profit-making entities. And at 58, national legislation may not, in implementing the exemption provided for under G, lay down materially different conditions for profit-making entities on the one hand and non-profit-making legal persons falling under 418 on the other. So what this appears to be saying is that you can't have, where the supplies are materially the same and the suppliers are materially the same, you can't have different criteria simply differentiating between profit-making and non-profit-making suppliers. So this is a point that I made earlier, that the UK couldn't say that Buckingham, BPP and the University of Law were excluded from the definition of suppliers which conform with the exemption. One can't say universities except for profit-making universities. And that's what this seems to show. But what one was looking, as I've already shown, the German VAT legislation does have a series of different categories. That wasn't the problem. It wasn't the fact that you've got a list of categories that was the problem, but it was differentiating in that list of categories between materially similar suppliers just on the basis of being profit-making or non-profit-making. And then in LUP, which was a case under point B, that's at 29. That was a case under 416C, and we've seen 416C a moment ago in the German list. That's at paragraph 7 on page 572 of the bundle. It's right at the bottom of the page, and you've already seen that in the translation a moment ago. And just to recollect what we saw on page 1012, there was a general exemption, and then different conditions were applied to B, C, D, and E. Hospitals in that list had to meet the conditions laid down in the tax code, you'll recall, while other establishments had to provide services under medical supervision. In the previous year, at least 40% of the services had to be provided to particular worthy persons. The issue or difficulty in LUP wasn't the existence of one set of conditions for private hospitals and another set of conditions for private diagnostic clinics or other establishments. The problem was that the gateway in 16C, in the case of diagnostic clinics, required that the services be provided under medical supervision. and that had the effect of excluding private laboratories such as LUP, who relied on paramedical services given by individuals who weren't doctors. So again, the issue is within one of the domestic gateways, this is 416C, there was discrimination within that gateway between medical treatment centres and other establishments outside of treatment centres such as LUP, who face the additional requirement of having to be supervised, the services having to be supervised by a doctor, and you'll see that at 55. In fact, 53 to 55. Actually, no, sorry. So the conclusions at 55. The bit about the doctor, sorry, is at 49 to 50. And then at 51,
So this time they say that the 40% threshold is perfectly all right.
they do. I think the issue, the bit that Mel and friends were relying on in this on point 2 was 49 to 51. And they, I think, refer to 50. Compliance with the principle of fiscal neutrality requires first that all of the categories of establishments be subject to the same conditions. But the point is that where the medical tests were carried out by a laboratory away from a medical centre, there was a requirement that the tests be carried out under the supervision of a doctor, which LUP couldn't satisfy. And what the court says there at 51 is that the condition in the middle of 51, the condition requiring that the treatment be provided under medical supervision, insofar as it is intended to preclude the exemption from applying to treatment given under the sole responsibility of members of paramedical professions, goes beyond the limits of the discretion allowed to the member states under B of the 6th directive. The term medical care in that provision covers not only treatment provided directly by doctors or other health professionals under medical supervision, but also paramedical services given in hospitals and the sole responsibility of persons who are not doctors.
But what goes wrong in this case is that German law restricted the kind of supply that would qualify for exemption. The supply is a supply either under medical supervision or not, but it's the same thing. The 40% would go to the supplier.
Yes.
So that a supplier who provided 39% of services to people specified in subparagraph 5b would not be entitled to exemption, and one who supplied 41% of services would be.
Yes.
Even though they're doing exactly the same thing.
Yes. That's correct. But the question is, can you have different, as we call it, gateways, as in different conditions for different types of supplier? And our understanding of LUP is, at least as far as the requirement of tests having to be supervised by a doctor, was effectively within this, as far as the same what the court was saying wasn't compatible with community law. It seems to have upheld at 53 and 54 the 40% requirement, but what it didn't like at 50 and 51 was the fact that medical tests, if they were provided outside of a hospital, had to be provided in the medical supervision of the doctor, and that had the effect of excluding the private laboratories such as LUP, which were not part of a treatment centre.
But that's because the nature of the supply, which had to be exempt under Article 13A(1)(b), was hospital and medical care. And what the judgment points out at the bottom of paragraph 51 is, in effect, that the German authorities had misinterpreted the phrase medical care.
Yes.
That is to say, they had excluded from the exemption a supply of the nature that was included in it.
Yes. It's the same point, effectively, as we made, or similar point, in relation to, it's the same type of issue as the Zimmerman point, because what you can't do is carve out within one, when you're specifying a gateway for exemption for a particular type of activity by particular suppliers, you can't carve out one type of entity, in that case private laboratories that weren't part of treatment centres, and say, in your case, you're not exempt unless you fulfil an additional requirement of the test being supervised by a doctor, which in your case you don't, and therefore you don't get exemption. And we say, finally, that the IGMBH cases of the same type of issue. That's at tab 45. IGMBH was, again, there were multiple routes to the exemption. One will see it's on 906, tab 45, is the again, there was effectively a discrimination point there, which was that the context of what's happening in that case, the relevant facts are on 906, 907. At the bottom of 906, we'll see under the heading German law, point B, hospital and medical care, and then there are two gateways into the exemption. AAA approved hospitals within the meaning of paragraph 108 of Book 5 of the Sozialgesetzbuch, and then CC, bodies which have been engaged to supply care by providers of statutory accident insurance in accordance with paragraph 34 of the Social Security Code. And then below that, at 8, headed approved hospitals, there are three, so that's referring back to the provision over on page 906. The three types were health insurance funds may procure hospital care only from the following hospitals: university hospitals, hospitals which are included in a land level hospital plan, listed hospitals, or hospitals which have included a care supply contract with the Landesverbände der Krankenkassen, the land level health insurance fund. But the what was there was a problem, which was while this might appear somewhat neutral, if one looks at what the issue is, it's at 21 and 22. The referring court, which was the Finance Court of Lower Saxony, noted that although these appear neutral, they weren't, because the exemption was effectively reserved for the first hospital to be included in the hospital plan and whose services meet specified needs under social security law. And because of the rules, which are further explained in 21, no additional hospital can be included in the hospital plan for the land in which it is located, or therefore conclude care supply contracts with the statutory health insurance funds where enough hospital beds for a particular speciality are already available within the land in question. 22. Consequently, the referring court considers that the system of turnover tax leads to similar services being treated differently. The advantage enjoyed by some hospitals over others is based solely on the fact that the former are older and were able to be the first to be included in the hospital plan or to conclude care supply contracts. It's a bit like saying that the only exempt universities are ones that were founded before, and then you just insert a date, 1967 or. The German court is pointing out that the effect of the German provisions, and we can pick that up just to finish this off at 64 onwards, on page 915. The court, the CJU, said that it is apparent from the information provided by the referring court that under German law, the establishment either has to be included in the land level hospital plan or has concluded care supply contracts. And then at 67, they pick up on what the National Court has said. In the middle of 67, you'll see, in practice, a private hospital would have no prospect of being included in the hospital plan for the land in which it is located or of concluding care supply contracts with the statutory health insurance funds if enough hospital beds for a particular speciality are already available within the land in question. So the court in Luxembourg picks up on what the Lower Saxony Finance Court has said. And then at 68, it follows from the information provided by the referring court that the providers of statutory accident insurance, land level health insurance fund associations and substitute fund associations all enjoy discretion as to whether to conclude an agreement with the hospital, and that the lender are not obliged to include in their hospital plan private non-university hospitals that carry on their activities under social conditions comparable with those applicable to bodies governed by public law. And then at 69, the exercise of such discretion depending on needs defined under social security law may, contrary to the principle of fiscal neutrality, result in similar private hospitals being treated differently as regards the exemption laid down in Article 1321B in respect of similar services supplied under social conditions comparable with those applicable in bodies governed by public law. So what are, and you'll see that repeated then at 70, we say that that would be equivalent, as I say, to some arbitrary distinction, say based on the age of the university, whereas in our case, the domestic gateway for universities is open to the appellants if they go through the process of obtaining DAPS and university title, or if they fulfil the conditions for being colleges of universities, if they enter a sufficiently close relationship with a university so as to be imbued with its objects. So that's what we say about point 2, except for my learner friend had a brief, I note the time, but my learner friend had a brief point about the FECs. I do realise I'm slightly behind schedule, but I only have a short point on point 3.
Right. Yes, Ms. Inglis.
I'm grateful, my lords. I'm going to address you on the issue of whether charitable status was a valid basis for distinguishing the appellants from FECs for the purposes of the education exemption. I'm particularly addressing here the points made in the appellant's skeleton at paragraphs 57 to 67, but I want to start very briefly with what the tribunals below concluded. I invite the court to turn very briefly to the FTT's decision at page 140 of the core bundle, paragraph 177. Here, the FTT concludes that the appellants were not comparable to FECs because FECs are required to be charities and the appellants are not. It's worth noting, as the UT notes, as we'll see in a moment, that the FTT had already affirmed at paragraph 23, and for your note, that's on page 115 of the core bundle, that the exemption status of an institution doesn't generally depend on whether or not the institution is a charity. But in 177, the FTT then adds that the UK was entitled to make exemption for FECs dependent on non-profit making status under Article 133A of the PVD. I submit that implicit in that statement is a finding that the UK was in fact exercising its discretion under Article 133A. I invite the court to turn now to the UT decision at paragraph 51, and this is at page 87 of the core bundle. Here, the UT records Ms. Shaw's submission that the FTT was wrong to hold at 177, that the
Sorry, I'm
appellants
behind
were...
you. Which page of the UT?
I beg your pardon, my lord. It's page 87, paragraph 51.
Yes.
The UT records Ms. Shaw's submission that the FTT erred at 177 in finding that the appellants were not comparable to FECs. The UT then notes paragraph 23 of the FTT's decision and concludes that the FTT had MDDP in mind when it concluded that exemption status doesn't ordinarily depend on whether an institution is a charity. But then it concludes that what the FTT, in the final sentence, it concludes that what the FTT was saying in 177 was, first, that the UK had decided to restrict exemption for further education to FECs, which under the applicable regulatory regime were required to be charities, which meant that they could not systematically aim to make a profit. And second, that the UK was entitled to do that under Article 133A.
And implicit in that conclusion is that the UK was entitled to exercise its discretion under 133A in relation to some suppliers, but not all suppliers.
Indeed, my lord, and I will return to that. The UT then approves the FTT's analysis, affirming at 52 that the FTT adopted the correct approach to fiscal neutrality in the presence of the supplier condition. In other words, the FTT was right to hold that FECs and the appellants were not comparable because they were not subject to the same legal requirements. Now, the appellants raised 3 objections to the tribunal's analysis here. First, at paragraph 58 of their skeleton, which for your note is at page 41 of the core bundle, they assert that charities, as a matter of UK law, are not precluded from systematically aiming to make profits. With respect, that is incorrect. The appellants refer to the public benefit requirement in section 21B of the Charities Act 2011. But the public benefit requirement is only one of the requirements that the Charities Act 2011 places on charities. Unfortunately, we have only very limited excerpts of the Charities Act 2011 available in the bundle, but over the luncheon recess, we handed up 2 sheets of paper containing sections 1 and 3 of that act. These have, of course, been also provided to the appellants. Section 11A provides that a charity in England and Wales is an institution which is established for charitable purposes only. Then turning to section 2.1, which appears at tab 9, volume 1 of the authorities bundle, page 186. Here we see that the definition of charitable purpose has two parts. By section 2.1a, the purpose must fall within section 3.1, and by section 2.1b, it must be for the public benefit. So merely existing for the public benefit is not enough. Turning to section 3.1, the second of the pages that we handed out, we see set out there a list of purposes, none of which mentions making a profit. And I submit that it follows from this that making a profit is not itself a charitable purpose. I also submit that that comes as no surprise. Returning then to section 1.1a, the reference to charitable purposes only thus precludes a charity from being established for the purpose of making a profit. And we see
What
this.
if it's an educational charity, which happens to, an educational body that happens to also make a profit?
Now, saying they're precluded from systematically aiming to make a profit is not the same thing as saying they're excluded from making a profit. And we know that some charities can make profit. And indeed, Part 10 of the Income Tax Act 2007, which the appellants allude to in their skeleton, deals with that situation where a charity does in fact make a profit. But there's a difference between being permitted to make a profit and being permitted systematically to aim to make a profit. The first has to do with accountancy, and the second has to do with purpose. And it is the purpose that is prohibited to FECs under UK charities law, as we have seen. And it is also that purpose which the member states are specifically permitted to take into account to make a condition for exemption in Article 133A of the PVD. There's a useful reference with respect to UK domestic law in the King's Crest case. I won't ask you to turn there in the interests of time, but in volume 2, tab 27, page 532, at paragraph 12, the UK states with respect to UK domestic law, quote, under domestic law, a charity must be set up for exclusively charitable purposes and therefore cannot be run for profit. And that's just an example of the CJEU confirming the position with respect to UK domestic law that I've just been setting before your lordships. In her oral submissions yesterday, Ms. Shaw referred to paragraph 57 of Zimmerman, which appears at tab 34, page 701. She referred to it in support of her submissions about the requirements placed on charities as a matter of UK domestic law. And we see that reference repeated in paragraph 59 of the appellant's skeleton. But that passage does not assist her. As my Lord Justice Miles pointed out yesterday, in Zimmerman at 57, the CJEU was making a statement about the kind of entities that can be recognized as charitable as a matter of EU law. If the court would very briefly turn up the relevant passage, tab 34, page 701. Starting at the end of the third line, we see that the court has held, in relation to the concept of organizations recognized as charitable by the member state concerned, as referred to in Article 3A, 1G of the 6th Directive, that concept is in principle sufficiently broad to encompass natural persons and private profit-making entities. The point, though, is that that reference to Article 13A1G shows that Zimmerman was concerned here with the meaning of charitable in the EU sense of the term, not in the domestic law sense of the term. And for the judge's note, we know from the King's Crest case that the term charitable has its own independent meaning in EU law. It's an autonomous concept, and the reference for that is tab 27, page 533.
But isn't all this beside the point? The reasoning of the CJEU is that member states have an option to make it a condition that a supplier is non-profit making. And the interpretation of the exemption cannot therefore exclude profit-making entities by definition, because otherwise the option would be completely redundant.
Indeed so, my lord.
So that's why they say that you can be charitable in the meaning of an exemption and yet profit-making. But if you're right that the UK has exercised its discretion under Article 133A in relation to FECs, and it was entitled to exercise that discretion selectively, then this discussion about what charitable means in EU law doesn't matter, does it?
No, it doesn't matter, and I'll return to that point about entitlement to to exercise the discretion selectively in just a moment. But my submission for the moment is just that the UT was right to recognize in the penultimate line of paragraph 51 that charities in the domestic law sense must not systematically aim to make a profit. So UK charities are within the scope of the thing with which Article 133A is concerned.
Yeah.
That's as far as my first point goes. The appellant's second objection appears at paragraph 60 of their skeleton. They claim that FECs are charitable because of Section 22A of the Further and Higher Education Act 1992, not because they satisfy the test for charitable status in the Charities Act 2011. Now, Ms. Shaw did not develop that point in her oral submissions, and our answer to it is set out comprehensively in paragraph 63 of our skeleton. In short, I submit that Section 22A does not confer charitable status on FECs, but rather requires them to have that status under the Charities Act 2011 as part of their qualification as FECs. Paragraph 63 sets out our case as to why that's true based on the legislative history. And for your note, the three successive versions of Section 22A appear at tab 2, pages 26 to 28. The fact that the current version of Section 22A arose as a consequential amendment on the adoption of the Charities Act 2011 appears at tab 11, page 188. And the relevant passage of Benyon as to the effect of consequential amendments appears at tab 52, page 1022. And now I come to the third point, about which my Lord Justice Lewison asked. The appellants say that even if Parliament was seeking to exercise its right under Article 33A of the PVD in singling out FECs for exemption, that it breached the principle of fiscal neutrality in doing so, since this restriction did not apply to all providers. As to this, I invite the court to turn to Article 133, which appears at tab 1, page 10. It worth noting, firstly, that Article 133 never states in terms that a restriction, an optional condition imposed thereunder needs to apply to all bodies who are not governed by public law that fall within a particular one of the 7 exemptions. The appellants say that the reference in the first paragraph of 133 to each individual case is a reference to each of the 7 enumerated exemptions, B, G, H, I, and so on. And that point is expressly set out in paragraph 65 of their skeleton. But that interpretation sits uncomfortably, I submit, with the double use of the word each in Article 133. So the first paragraph already specifies, before we get to the list of the 7 exemptions, that member states may make the granting to bodies other than those governed by public law of each exemption provided for in points B, G, etc. So if there were any doubt at all about the member states' ability to impose a different cocktail, if you like, of the specified conditions in respect of each of the 7 exemptions, then that first each, together with the phrase one or more of the following conditions at the end of the first paragraph, would completely settle the point. There would be no need to add the further specification in each individual case to achieve that clarity. I submit that a more natural explanation for the inclusion of the phrase in each individual case in the first paragraph of 133 is to allow the member states to impose one or more of the specified conditions on the different types of supply and or supplier mentioned in each of the 7 exemptions. So the structure of Article 133 itself supports the idea, I say, that there can be different specified conditions applying within each of the listed exemptions. That interpretation is also supported in case law. This can be seen firstly from the Dornier case, where we've already spent considerable time. And in that case, the court considered the scope of what is now Article 133A. Dornier, as we've already heard, concerned exemption B for hospital and medical care. I invite the court to turn to tab 25, page 500. Here at paragraph 5, we see the text of the exemptions B, C, and G. And then down at 6, the text of what is now Article 133 appears. And the first bullet point corresponds to what is now 133A. And it's materially the same. I invite the court to flip over to page 509 and to have a look at paragraphs 64 and at the top of the next page, 65. From 64, we see in the second line that exemption B does not specify the conditions and procedures for recognition for non-public law establishments, so it's for the member states to lay down the rules for that recognition. Then in 65, the CJEU quotes from what is now 133 in excerpt form, mentioning exemption B only. Notably, however, the court retains the phrase subject in each individual case. So just above little a, we see member states may make the granting to bodies other than those governed by public law of each exemption provided for in 1B, subject in each individual case to one or more of the conditions referred to therein. The fact that the court retains the phrase subject in each individual case when referring only to exemption B shows that the reference to each individual case in what is now 1 through 3 is not a reference to each of the 7 enumerated exemptions, but rather to individual categories within each specific exemption. And that accords with the approach of the tribunals in the present case. In particular, the UT at paragraph 51, where, as we have seen, the UT affirmed, and as my Lord Justice Lewison pointed out, that under Article 133A of the PVD, the UK could restrict the education exemption in relation to further education to FECs, as defined in the FHEA, which requires them to be charities. We see a similar approach taken by the court in the more recent case of Golf Club Slosh-Igling, which my learned friend Mr. Hill took you to this morning and which involved exemption M. I invite the court to turn to volume 3, tab 41, and to read page 819. The relevant paragraph is paragraph 49. Here, in the first sentence, the CJEU affirms that Article 133A allows member states to make the granting of the exemption in M, the sport and physical education exemption, to bodies other than those governed by public law, subject, again, in each individual case, to the condition that the bodies in question must not systematically aim to make a profit. So here again, we see the CJEU applying the specification in each individual case within the context of a single one of the 7 exemptions listed in Article 133. This shows that the phrase "in each individual case" does not refer to each of the listed exemptions as a whole, as the appellants claim. Instead, it refers to individual categories of supply within each exemption, those being, in the case of exemption M, certain services closely linked to sport and certain services closely linked to physical education, in each case to persons taking part in the same. Accordingly, I submit that it was open to the UK, to Parliament, to impose a non-profit-making condition specifically in relation to further education, as the UT found at paragraph 51. Of course, further education being a domestic category does not map precisely onto one of the categories of education specified in exemption I, although further education has traditionally been associated with vocational training, which is a specified category, and it might be that when Parliament specified FECs for exemption in Note 1C, that it had the EU category of vocational training in mind. However, we know from FBT in the Court of Appeal, at paragraph 54, which my learned friend Mr. Hill has discussed at length. The reference is tab 20, page 370. It was open to the UK under EU law to decide which non-public bodies were to qualify for exemption and then to list them in the relevant legislation. So there's nothing wrong, as a matter of EU law, with Parliament's recognition of FECs, and the appellants specifically accepted that yesterday. The point for our purposes, as the FTT found at paragraph 177, was that the FECs and the appellants were not comparable because they faced different legal requirements. And so the UK's recognition of FECs for exemption does not mandate a similar recognition for the appellants. In her submissions yesterday, my learned friend Ms. Shaw sought to rely on Zimmerman to bolster her claim that the discretion in Article 133A must be exercised in an all or nothing sort of way across a specified VAT exemption. But Zimmerman does not assist them in that submission. And I invite the court to turn very briefly to Volume 2, tab 34, page 700.
Page 700.
700. And in paragraph 55, at the bottom of that page, the CJEU expressly affirms that fiscal neutrality could not prevent Germany from refusing exemption under what is now Exemption G to profit-making entities under what is now Article 133A. In other words, fiscal neutrality cannot override the member state's discretion under Article 133. However, in Zimmerman itself, and we see that at paragraph 56, the court says that there was no information placed before the court to suggest that the Federal Republic of Germany has availed itself of that option. So Zimmerman was not a case about placing limits on Article 133A, but rather a case in which the court determined that Article 133A was not in play at all. Germany had not availed itself of that option. And the CJEU's subsequent statement in paragraph 58 about the impermissibility of different conditions for profit-making and non-profit-making entities needs to therefore be understood in that context. The court was not seeking to restrict the express discretion reserved to the member states under Article 133A, but was speaking into a situation where that discretion had not been exercised. In the present case, by contrast, two tribunals have acknowledged that the UK has availed itself of that discretion in Article 133A by limiting exemption in relation to further education to FECs, which have to be charities according to the regulatory regime in which they operate. And as the CJEU affirmed in Zimmerman at 55, fiscal neutrality cannot prevent the UK from doing that. In her oral submissions yesterday, my learned friend Ms. Shaw referred to paragraph 28 of SAE. I'm not going to ask you to turn there. The reference is tab 21, page 380, where Lord Kitchen notes that the UK has not exercised its discretion under Article 133A with respect to Note 1B, universities and colleges of universities. But Lord Kitchen didn't say anything there about what the UK had done in relation to Note 1C, further education in FECs. I submit, therefore, that it remained open to the FTT and the UT, consistently with SAE, to find that the UK had exercised its discretion under Article 133A in respect of further education in FECs. Ms. Shaw accepted yesterday that if the UK had exercised its discretion under 133A, that the appellants could not argue with their exclusion. And I submit that that is exactly what has happened here, in fact. So unless I can assist your lordships further, those are my submissions.
How do you know whether the UK has exercised its discretion except by looking at the legislation?
Well, in this case, we know because the tribunals have concluded as a matter of fact, as well as a matter of law, that they have done so.
Thank you very much, Ms. Inglis.
Grateful, my lords.
So then, on to the TEFL point, we say this is a relatively short point, and that is because there are two flaws, we respectfully say, in Mr. Blades' argument, and they relate to 2 points which were raised by the court yesterday. One is what one might refer to as the magic bullet point, which I think my Lord Justice Henderson referred to, and the second was a point which my Lord Justice Miles referred to, which is the question of treating notes 1F and 2 as being separate. We say that therefore it's unnecessary to deal with in detail with what Lord Justice Sheeman said in Pilgrims and or the interpretation of FBT in the Upper Tribunal. We maintain what we say in our skeleton at 67 to 75, but we don't need to go into that in detail. So our focus is on what we say the two flaws in the argument are, and we say if the Court of Appeal follows us on that, then the TEFL issue doesn't add anything to issue 1, i.e. one goes round in a circle, we say, and we say on either of our two analyses, which I'm about to get to, one has to either note 1F and note 2 are not incompatible with EU law, or if there is incompatibility, it's effectively for both provisions. Therefore, one has to get onto the question of direct effect, and direct effect takes one back to all of the issues covered by the grounds 1 and 2, issue 1, grounds 1 and 2. So the TEFL issue 2 point doesn't add anything to the debate. It's not a separate route to all of IMAN's supplies being entitled to exemption. I'll explain our reasoning. So just to very briefly recap Mr. Blaze's argument, he says that the supply condition in point I is autonomous, therefore the member state cannot restrict the types of education which they are required to exempt. The discretion only applies to the supplier condition and not to the supply. If IMAN qualifies for exemption under point I as another organisation recognised by the member state concerned, all of its supplies of education which fall within point I would also be exempt. The only supplies which wouldn't be would be supplies which aren't education at all, and he gave the example of research. What he then does is analyse notes 1F and 2 separately, and he says that 1F is consistent with EU law. It's a nomination, a lawful nomination of bodies providing TEFL as having similar objects to bodies governed by public law. But he says that note 2 is inconsistent with EU law because it's a restriction on the types of supply of education which satisfies the supplier condition can treat as exempt. On that analysis, he effectively has created his magic bullet, and therefore if a supplier such as IMAN provides TEFL, it's then exempt for all of its supplies of education, only excluding supplies which aren't education. And we say that there are two problems with that argument. The first is what you might call the magic bullet element of it, and the problem there is a problem of EU law, and that is exemplified by MDDP. The problem is that, as we've seen from the MDDP case, which was a Polish case, the CJU said that the exemption in point I doesn't permit member states to grant the supply of the exemption to all private organisations by including those whose objects are not similar to those of bodies governed by public law. And then the court goes on to say that you can't have a general exemption for education. And we say that's precisely what Mr. Blaze's argument in its magic bullet nature would in effect allow for a general exemption for all education, provided that the supplier made at least some supplies of TEFL. Because then, provided you made supplies of TEFL, there would be no, or a supplier would be entitled to exemption regardless of whether of their place in the national regulatory framework and regardless of any of the other factors set out in the Kugler list of factors which a member state can rely on in deciding which entities to recognise as being similar to bodies governed by public law. So the first problem with Mr. Blaze's argument is that if Note 2 is inconsistent with EU law, which is what he says, the result is then effectively a general exemption for education. And the problem with that is that that's inconsistent with MDDP. So then Note 1F must also be inconsistent as contrary to MDDP. You can't strike through Note 2 and then end up with Note 1F on its own, which is contrary to MDDP. So you then have to strike through both Notes 2 and 1F. In those circumstances, what MDDP says at 51 to 54 is that IMAN would have to rely on direct effect to establish whether it was entitled to the benefit of the exemption in point 1. And that requires the UK courts, in looking at direct effect, according to MDDP at 54, to examine the object and conditions of IMAN's activity by comparing them with those of other UK bodies providing education which do benefit from the exemption. Now that's precisely what the FTT and UT did. My learned friends say in point 1 or issue 1, grounds 1 and 2, that they applied the wrong test. But if they applied the right test, then the UK courts have already carried out that exercise. And therefore, if we're right that 1F cannot stand consistently with MDDP, cannot stand on its own consistently with MDDP, because it would provide effectively for a general exemption if Note 2 is found to be incompatible, then one ends up with precisely the issue in issue 1, which is to examine the object and conditions of IMAN's activity and whether, applying direct effect, IMAN would be entitled to exemption in accordance with EU law. So that is the first problem, which is a question of EU law. There is a second problem with Mr. Blades' argument, and that's effectively a mixed issue of EU law and UK law, which is that he treats notes 1F and 2 as distinct provisions, and he says that what the court is entitled to do is find 2 to be incompatible and 1F to be compatible, even though they're both legislative provisions dealing with the same point. There is another analysis to that, which is that what effectively the issue is here is to construe 1F and 2 consistently with EU law, and that would be the first, if possible, and that would be under the Mar-Leasing doctrine. So we say that one can't simply separate out 1F and 2 because they just happen to be in different bullet points if they are effectively dealing with the same thing. The fact that on the page they're simply written as 2 bullet points doesn't change that, and therefore the correct analysis is to look as to whether, first of all, Mar-Leasing allows you to, the Mar-Leasing doctrine of European law allows you to construe the whole of 1F and 2 consistently with EU law, and if not, then you have to find both 1F and 2 to be incompatible, and then again you end up with disapplication of both 1F and 2, and that gets you straight back into the point which I've already made, that you then have to look at direct effect, and that takes you straight back into all of the issues that we've just discussed in issues 1, grounds 1 and 2. I probably don't need to cite case law for this, but the most recent case, or what probably the leading case on this point, was laid down by Your Lordship's Court in Vodafone 2. We have copies if necessary, but I'm sure the court is familiar with this. Vodafone 2 was in 2010, at 2 WLR 288, and the guidance on leasing was at 37 and 38. And that is those are the list of factors that the court will be very familiar with, that the leasing doctrine allows a muscular approach to construction, but the interpretation should go with the grain of the legislation and be compatible with the underlying thrust of the legislation, and cannot be adopted which is inconsistent with a fundamental or cardinal feature of the UK legislation, as that would be amendment rather than interpretation. We say that striking through or disapplying note 2 in effect creates a new exemption which is inconsistent with a fundamental feature of notes 1F and 2 read together, and that cardinal feature is that a body providing TEFL is only exempt insofar as it provides TEFL. So on that analysis as well, you can't achieve the result that Mr. Blaze is seeking to persuade you to reach, which is that note 1F stands, note 2 is found to be incompatible, and you magically end up with a body providing it supplies TEFL being exempt for all of its educational activities. We say that on both of those two analyses, the MDDP point and also the leasing point, if that notes 1F and 2 are either both compatible with EU law, or if they're not, both of them are incompatible, and therefore one has to then rely on direct effect, and that takes you straight back to issue 1, which is a consideration of the object and conditions of Ironman's activity, comparing them with those of the other UK bodies providing education which do benefit from the exemption, and that's what the FTT and Upper Tribunal have already done, and what the thrust of issue 1 is. And so therefore, for those two reasons, the magic bullet nature, which is inconsistent with MDPP, and the leasing point, reading the attempt to read 1F and 2 separately, one ends up returning effectively to the issues in issue 1, and therefore the TEFL point doesn't add anything to that. The magic bullet point also has a further feature, which is it would also potentially be inconsistent with fiscal neutrality, because of a supplier who provides some TEFL would be exempt for all of their supplies of education, but a supplier who doesn't provide any TEFL would be still excluded from exemption, even if their other supplies were identical. So unless I can assist the court further, those are the revenue submissions.
Thank you very much, Mr. Any reply, Ms. Shaw?
Can I make 4 points in reply to ground 1, please? Firstly, we say that the central flaw in the revenue's response to this ground is that it confuses the question of what factors can be taken into account in the exercise of the recognition discretion, which is what Kugler, Dornier and Kingscrest address, with the separate question of how to assess the similarity or comparability of supplies, which is what Solvelt, Rank and Life address. And the question of similarity, simply didn't arise in Kugler, Dornier, Kingscrest, Zimmerman, IGMBH, MDDP, all the other cases that we've been through yesterday and today. So whereas Kugler, Dornier and Kingscrest tell us that the regulatory framework is one of the factors that can be taken into account, it's rank that tells us that the similarity of supplies by reference to that factor is assessed from the point of view of the consumer. And in particular, it's paragraph 50 of rank, which says in terms that it is only in exceptional cases where differences in the regulatory framework will be such as to create a distinction in the eyes of the consumer. So where, as in this case, from the point of view of the typical consumer, all supplies of designated higher education are subject to the same essential regulatory requirements, the regulatory framework is not a factor that can justify a difference of VAT treatment between two suppliers of designated higher education. The regulatory framework would, however, justify a difference of treatment between providers of designated higher education on the one hand and providers of non-designated higher education on the other, because that latter category is not subject to the regulatory framework, just as TNT was not subject to the regulatory framework applicable to Royal Mail in the provision of the universal service. And in our submission, it is simply wrong to suggest that what is said by the court in rank, in particular paragraph 50, does not apply where the particular supply of services at issue includes a supplier condition when the court refers in rank to cases such as Kingscrest, EC in Germany, Solvelt, and TNT, all cases where the supply of services at issue in those cases included a supplier condition. In particular, in paragraph 50 of the court's judgment in rank, it makes explicit reference to the supplier. It says differences in the regulatory framework governing the particular supplies of services at issue, such as whether the supplier is subject to an obligation to provide a universal service, may, in exceptional cases, create a distinction in the eyes of the consumer. So we say there is no qualitative difference between a supply condition and a supplier condition in terms of the assessment of similarity or comparability. The assessment is always from the point of view of the consumer, and nor is knowledge or otherwise of the particular factor on the part of the consumer a relevant criterion. In rank, as my learned friend pointed out this morning, the question was whether differences in the location of the random number generator, whether it was inside the machine or located elsewhere, was what was an issue. And the question was simply whether that was a factor that would have affected the consumer's choice. Whether the consumer is aware of the location of the random number generator is neither here nor there. In TNT, the question was whether the regulatory framework set out in Royal Mail's license agreement was material to the consumer's choice, as the court explains in rank. Again, whether or not the consumer is aware of the particular license obligations is neither here nor there. In this instance, the question is whether differences in the regulatory framework were material to the consumer. In fact, the consumer would have been perfectly well aware of what the regulatory framework requirements were in this case, because they need only pick up the operating framework. So in our submission, there is no answer to what is said in paragraph 50 of rank, and the Revenue have not offered one as to why, if the assessment of similarity or comparability is so different in relation to the supplier condition, the court refers to TNT, and in particular to differences in the regulatory framework being assessed from the point of view of the consumer. My second point in reply is my learned friend suggested this morning that the courses supplied by the appellants are not similar to those supplied at universities, colleges of universities and FECs, and that is factually incorrect. It's clear from the findings of the FTT, it's paragraphs 109, 110, 116, 129 and 144, that the courses supplied by the appellant are the same or similar to those provided by universities, colleges of universities and FECs. And indeed, the Upper Tribunal accepted that that was the position in paragraph 32 of its decision. The basis of distinction between the appellants on the one hand and universities, colleges of universities and FECs on the other is not on the basis that the courses they supply are different. It's on the basis that university title and DAPS do not apply to the appellants and that they do not have charitable status. So that is the only basis on which we have been distinguished from other recognised providers of designated higher education. The third point I wanted to make in reply it concerns what is said by the court in paragraph 36 of Bridport. In my submission, all that the court is saying there is that the exemption implies the existence of divergent conditions for different suppliers. Whether or not suppliers are different is a question for fiscal neutrality. What the court cannot be taken to be saying in paragraph 36 in my submission is that similar supplies by similar suppliers can be treated differently. And then my fourth point in reply to ground one is that life is not per incurium. It is correctly decided and it is binding authority. It was decided on the basis of the same authorities that we have looked at yesterday and today, and to which it refers in the body of the judgment. The point that my Lord Justice Lewison, or the case that my Lord Justice Lewison referred to, Starmark Enterprises and CPL Distribution, that concerned a slightly different point. In Starmark, there were conflicting decisions of the Court of Appeal, and a third Court of Appeal had to decide which of those two authorities it was going to follow. So that is not a situation which arises here. We do not have conflicting decisions of this court. We just have life. And as I said, in my submission, life is correctly decided. It is not per incurium, and so Young and Bristol Aeroplanes is the authority on that.
What about this new European case that Mr. Hill produced?
Yeah, so what I would say about, I think it's pronounced Angada Shakona.
Well, I think I prefer to say Minister of Justice. It seems.
Minister or Mr. Boyle, Ronald Boyle. So in our submission, this is not authority for the radical proposition that the revenue now rely on it for, namely that decisions of the National Court on matters of EU law are somehow not binding and that it's open to a subsequent court to re-decide matters which have already been decided. All that Shakona is authority for is the well-established proposition that national courts must be empowered to disapply any measure of domestic law, whether it's legislative or a common law rule, if that rule is contrary to EU law. That's all that Shakona tells us. So that was all I wanted to say on ground one. Ground two, I have 3 points in reply, if I may. My first point is that the revenue's response to this ground is predicated on a straw man. Our case, it is said, is that you cannot have multiple gateways to recognition. And as I said yesterday, that is not our case. We do not take issue with the existence of multiple gateways. What we take issue with is our exclusion from those gateways on the basis of conditions which do not apply equally to all. In the same way that Mrs. Zimmerman's complaint was not that there were multiple gateways to recognition under German law, it's that she was excluded on the basis of the 2/3 funding requirement, which didn't apply to all recognised voluntary welfare associations.
Do you mean there's an ambiguity in possibly, which would be helpful to sort out. Do you mean not treated the same way as other bodies within a category? Or do you mean that somehow if you can pick out a characteristic in relation to one category, that characteristic has to apply to all?
It has to apply. So what the case law says is that as regards similar supplies of services, every recognised or every non-public body for the purposes of recognition must be subject to the same conditions for recognition. So in my submission, the similarity of supplies of services exists here at the level of designated higher education. I don't need to submit that there could not be different conditions for, say, young person's education or vocational training. I'm saying that what the case law establishes is that if you are a provider of vocational training or young people's education or school or university education, which is our category, all providers of similar school and university education, in this instance that is designated higher education, not just any higher education, designated higher education, which qualifies for the same tuition fee funding, all suppliers of designated higher education must be subject to the same conditions of recognition.
But that means you can't, so if you take exemption 1I,
Yeah.
let's just take university education as a concept,
Yeah,
which is a concept of an autonomous concept.
it is, yes.
Does that mean you can't have a list of 2 or more categories within that?
Absolutely not. You can have as many gateways as you like. It's just that everybody who supplies that category, who makes those similar supplies, must be subject to the same conditions. So as I mentioned yesterday.
Sorry to interrupt you, but if you have more than one gateway, won't that necessarily be defined by different criteria? Otherwise you only have one.
Well, so the condition, so if there was a gateway for alternative providers of designated higher education, the condition would be that the supplier of services is either a university or college of a university, an FEC, or an alternative provider of designated higher education. And that's what the German legislation does. What is not permissible, as Zimmerman explains, is to have 2 different gateways. You can either be a provider of outpatient care and subject to the 2/3 requirement, or you can be a recognised voluntary welfare association. So those are the 2 gateways. And Mrs. Zimmerman was entitled to say, you cannot exclude me from the gateway to recognition on the grounds that I do not meet the 2/3 funding requirement, because that is not a condition applicable to the 11 recognised voluntary welfare associations.
But take university education, for instance. Wouldn't the UK, I'll ask a question, would the UK be entitled to say that university education is limited to bodies with DAPs and colleges so closely affiliated with them as to merge into a DAP university?
I would say no. It could limit it to institutions with DAPs.
Right.
But it can't then extend recognition to bodies that don't satisfy that condition. And I would say that simply being imbued with the educational objects of a university does not give you DAPs. It clearly doesn't give you DAPs. So if that is the condition, then it's not permitted. The UK can limit it just to institutions with DAPs.
Right.
But it's because it has exempted or recognised colleges of universities and FECs who do not have DAPs or university title, that the problem arises.
I was going to put this question about FECs. Is that university education or is that young people's education?
I would say that's the same as us. It's part of university education. FECs are like us. The reason that they don't qualify for DAPS, and DAPS is, if you like, a first step towards university title, is that you have to have a majority of your students studying on level 6 courses, which is a degree course. And HNC and HND courses are the levels below, level 4 and level 5, and they are equivalent to year 1 and year 2 of a degree course. So in my submission, higher education is equivalent to university education. It's just at different levels within that university education.
But universities and FECs are different from one another.
Absolutely, yes.
But you accept that you can have those two categories. You just say you need another one. But just pausing
that's exactly
there
my
a minute.
case, yes.
If you can have two categories, both of which are within the Euro concept of university education, then I can't help going back to my question. Those are different subcategories, if you like, and they have different conditions attached to them. So it can't be the case that the same conditions have to apply to all of to all of the subcategories.
The condition is that you are either a university, college of university, an FEC, or a designated provider of higher education. You have to meet one of the gateways. The problem is we cannot be excluded from a gateway on the basis of a condition in the case of B that we don't have DAPS or university title, or from C on the basis that we don't have charitable status, when those are not conditions that are mutually, that apply to within B and C.
But they don't apply as between the two categories because the two categories are different. So
Well, they are.
you
but-
can't say, well, someone in this category doesn't have to do this, and someone in the other category doesn't have to do that, and then say,
Well, that's exactly what the court says in Zimmerman.
well, okay,
Mrs. Zimmerman cannot be subjected to the 2/3 condition because it does not apply to the other gateway to recognition, which is being a recognised voluntary welfare association. And it was the same point as made by the court in Lupp. The issue in that case was that the medical supervision requirement did not apply to the provision of paramedical services at hospitals. So the condition for medical supervision only applied to certain recognised bodies, and that's set out in paragraph 7 of the court's judgment. And if you go back to the domestic legislation at issue there, my Lord Justice Lewison, you made a point about, isn't that a condition attaching to the supply, the medical care?
That seemed to be the way the court approached it, because they stressed that medical care includes care delivered by paramedics.
They do, but they explain that the issue is that condition, the condition for supervision, does not apply to the provision of paramedical services in hospitals. And so it is a condition for recognition which doesn't apply to hospitals, and that was the issue in Lupp. So point 2, I've probably already touched on this, but lest there be any confusion about what our case is, it is that all providers of designated higher education must be subject to the same conditions of recognition. And that's a straightforward proposition which derives from paragraph 43 of Zimmerman, which says in terms that all non-public bodies must be placed on an equal footing for the purposes of recognition for the supply of similar services. So there can be no doubt we are supplying similar services with our designated higher education, and it follows from what is said by the court in Zimmerman that alternative providers must be placed on an equal footing for the purposes of recognition. And then finally, on the issue of the selective application of Article 133A, we say that a selective application is precluded by a plain and straightforward reading of Article 133 itself. The words in each individual case plainly refer to each exemption and not to bodies other than those governed by public law. We say that that follows or is supported by paragraph 56 in IGMBH, where the court confirms there that the requirement to recognise under exemption B applies to all non-public bodies referred to in that provision, and it relies in support of that propositional conclusion on the discretion under Article 133, which in our submission suggests that the discretion under Article 133 is either must be exercised in relation to all non-public bodies or to none. Moreover, that interpretation is consistent with fiscal neutrality, which requires that all non-public bodies within the particular exemption be subject to the same conditions of recognition. So it is true that if the UK had properly exercised Article 133A, its discretion under 133A, and made all non-public bodies subject to the condition for the purposes of recognition for the exemption under I, then it would not lie in the mouths of the appellants to say, well, there's no material difference between us profit-making bodies and all these other non-profit-making bodies. But that, we say, is not what the UK has done. Those are all of my submissions in reply.
Just show me where in your skeleton argument you attack the finding of the FTT and the UT that the UK did exercise the discretion. But since we haven't got your grounds of appeal, it's not easy to see where it fits. But
It's 62.
52.
62.
62. Right. Yeah, no problem. 62 and 63. Yeah. Yes, thank you.
I'm just going to hand over to Mr. Blades.
I shan't take long, I've got 4 very short points. The first is on the magic bullet point, as it was put, that my construction of Note 1F would essentially leave a general exemption for education, which was what was said to be the problem in MDDP. The response to that is that the problem in MDDP was that there was a general exemption without regard to the objects of the entity providing the education. You see that at paragraph 35, page 724. On my construction of Note 1F, you wouldn't have that problem because the entity has been recognised. It's not a general exemption for education for anybody, it's a general exemption for education for a body that's been recognised.
It might be a really small part of your business.
It might be, but it's
and the services that you provide.
That's right, it might be, but you're still recognised nonetheless. And as I showed you in Open University, the recognition is not in respect of TEFL. Second point, on the submission that Note 1F and Note 2 must be read together, the reason that's given for that is that they're dealing with the same subject matter, and I say there's no principle of law that says that is how the principle of disapplication applies. They are dealing with the same subject matter, but they're doing different things. One's about recognition, one's about supplies. In the context of disapplication, the court is required to find the offending provision or provisions. And as I said yesterday, there's nothing wrong with Note 1F. There's no reason to throw that out along with Note 2. Third point, you're invited to give Note 1F and Note 2 a conforming interpretation under the Marleasing principle. My learned friends don't explain exactly what that conforming interpretation is. My submission, however, is if that interpretation means that an institution is only recognised for some of its supplies, then that's a partial recognition, and that's not an interpretation that conforms with EU law, because partial recognition is impossible. So it might be an interpretation, but it's not a conforming interpretation. The final point is that it said that my submission that Note 2 should be struck through is not compatible with the Marleasing principle. I'm not arguing for a conforming interpretation, I'm arguing for disapplication. And the Vodafone case that was referred to expressly delineates those two concepts at paragraph 26. Those are my submissions.
Thank you very much, Mr. Blades. Well, you've raised some knotty problems, so we will think about them. You will get a draft judgment in due course. It will come under a strict embargo, which means what it says. It will be your opportunity to correct our English, but not our reasoning, and not to introduce new points or arguments. We would hope that in the light of the draft, you will be able to agree an order disposing of the appeals. If you can't agree a form of order, please make short written submissions, and we will make the form of order that we consider to be appropriate. The eventual hand down will be done electronically by emails to those on the distribution list and released to the National Archives. Thank you all very much.
Court rises able.